Who decides if you have capacity, and is it clear?
Capacity is a legal question or legal concept by which we seek to make sure that someone is only responsible for the actions that it's reasonable to hold them responsible for. Capacity is relevant for enduring powers of attorney for two reasons. Firstly, you need to have capacity to sign an enduring power of attorney, and I'll talk in a minute about what capacity means. Capacity is also relevant with enduring powers of attorney because often an enduring power of attorney will only become activated if a person loses the capacity to make their own decisions. Now, with financial enduring powers of attorney, you can choose to have the enduring power of attorney active immediately or on the loss of capacity to make particular decisions. I put the Northern Territory at one removed from that. They have a particular requirement. How we assess capacity. Capacity in the end is a legal test and it is informed by medical opinion. But there's now a pretty standard four-pronged test of capacity, which means that a person understands the decision they're making, they can retain information relevant to the decision, they can use or weigh up competing information relevant to the decision, and they can communicate that decision in some way. It doesn't have to be verbal. So that's the test of capacity. Ultimately, when push comes to shove, it is the State and Territory Civil and Administrative Tribunal which is the umpire about whether a person does or does not have capacity. It's a complex topic because we increasingly see capacity as decision specific, which means that you might have capacity to make one particular decision, a simple financial transaction, but you might not have capacity to make a more complex decision. So capacity is decision specific. This causes some difficulty with the operation of enduring powers of attorney, which like to imagine a bright line of having and not having capacity, but that's a complexity with which we have to live.
And how do you navigate it?
With great care, and I always say, when an attorney is, for instance, seeking to exercise power under an enduring power of attorney and there is some question about whether the principal does or does not have capacity, and let's imagine the enduring power of attorney is only active on the person's incapacity. What I advise the attorney in that situation is to keep checking in and making sure any decision they make on behalf of the principal accords with what the principal wants. Then there's no problem because you're effectively making the same decision.
It seems like some attorneys can convince doctors and lawyers that a person doesn't have capacity, so they can activate the enduring power of attorney. How do you defend yourself?
The first point I'd make in response to that question is to say you want to appoint a person or people you trust and from whom you don't need to defend yourself. Having said that, there are ways in which a person can build in safeguards to prevent that situation from occurring. For instance, you can specify in the document that you want several medical experts to announce or agree that you no longer have the ability to make your own decisions before this particular instrument becomes active. You can, for instance, say you want a trusted GP to come to that determination before the instrument becomes active. I would caution people, though, to make sure that the enduring power of attorney is workable. So, for instance, if you specify a particular GP you say has to say, I've no longer got capacity to make my own decisions, you want to make sure that GP is going to be around when questioned on this topic, because if they're not, suddenly the instrument would become void. So you want to be a bit careful in how you craft that. But there are ways of guarding against that concern.